You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. So, okay.
On or about March 26, 2025, an officer was on patrol.
In the opening moments, Judge Fleischer lays out the charges, DWI and evading arrest. Both are serious, carrying the possibility of jail time and thousands of dollars in fines. The judge reminds Mr. Salas of his rights, but the tension is already building. You can feel the weight in the room, 2 major charges and a long night. Ahead for this defendant, who else thinks the judge's tone already sets the stage for what's coming.
On Gulf Freeway in Harris County, Texas. The officer observed a motor vehicle disabled in the left hand with grass speeding, dividing southbound and northbound lanes of traffic. The motor vehicle had multiple airbags deployed and all 4 tires appeared to be damaged. On arrival, the officer observed additional motor vehicle disabled on the open access roadway. What was formerly a car dealership. The officer observed the witness walking towards the officer, trying to get the officer's attention. The witness said 5 minutes prior to the officer's arrival, the defendant approached the witness.
The officer's report paints a messy scene. Airbags deployed, all 4 tires damaged, the car stuck in the grass dividing lanes of traffic. This wasn't a simple mistake. It looks like a full-on collision. A witness tries to get the officer's attention, saying the defendant demanded to use his phone to call his mother. The image is chaotic, and you can't help but wonder, why was he so desperate to leave the scene?
After the witness tires were blown out, the witness informed the officer that the defendant demanded to use the witness's phone. The witness advised the officer that the defendant wanted to contact the defendant's mother to pick up the defendant from the scene. The witness told the officer that the defendant continued to approach aggressively and that the witness told the defendant the witness would call the police if the defendant did not stop. The witness said the defendant fled the scene on foot. The witness described the defendant's clothing, and the officer observed the individual matching the description running and approaching the scene of the incident. As the defendant approached the scene of the accident, the defendant began walking in a parking lot adjacent to the freeway. The officer gave loud verbal commands for the defendant to stop. The defendant fled on foot on the grass along a ditch. The defendant slid down a ditch and the defendant crossed the road.
As the officer approaches, the defendant doesn't wait around. According to the report, he runs, sliding into a ditch, crossing a creek, hopping a fence, and fleeing for miles before finally being detained. This is one of those moments where the courtroom collectively raises an eyebrow. For miles, on foot, would you run for miles to avoid police, or would you just stay put?
A creek, then find the fence attached to private residence, and fled on foot for approximately 0.4 miles before he was then detained by his police department and turned over to deputies. The scene was moved to a shell station to continue the investigation. The officers contacted the defendant. The officers observed a strong odor of alcoholic beverage emitting from the defendant, and the officers observed the defendant had red glossy eyes, slurred speech, dry mouth, repeating phrases, and agitated demeanor.
You say a shaky demeanor?
Sorry, agitated demeanor.
When officers catch up with him at a gas station, the signs are obvious. The smell of alcohol, red glossy eyes, slow speech, shaky demeanor. At first, he denies drinking, then denies drugs. Then finally admits he's been off for a couple days and took PCP or cocaine. This sudden shift, denial, then confession, only adds more drama. Is this honesty, panic, or something else entirely?
And the defendant denied drinking alcohol and initially denied drug use, and then stated that he had been off for a couple of days and had consumed paste or coke. The officer, through training experience, knows this to be represented cocaine. The defendant admitted that he was going to a girl's house when the incident occurred and agreed to perform standardized field sobriety tests. Those were administered, and the officer observed success exclusions on the HGN. The officer did not administer the walking tour of the one-leg stand due to the defendant injuring his feet.
The defendant claims he was heading to a girl's house when the crash happened. He mentions he ended up in the grass because he was scared, and then blames a Mexican driver for swerving in front of him. The judge listens closely, but the story isn't lining up. The inconsistencies only raise more questions. Do you think he's telling the truth, or trying to cover himself?
The defendant consented to a breast sample, which was not completed due to interference being detected. The officer obtained a search warrant for the defendant's blood, and there was a blood draw.
Okay.
Your Honor, may I comment?
Please.
I might have missed something, but besides the state saying that my client said he was going to someone's house, I didn't hear any operation facts.
I mean, he admits driving. He's by the car when the officers get there, right? Is he by the car when the officers get there, or where is he?
From what I have, Your Honor, he has fled the scene when the officers get there, and then comes back to the scene.
Okay.
To the officers. The witness.
Does the witness put him operating at all?
Yeah, just one moment, Your Honor.
If you tell.
Yeah, all I heard is going somewhere. It doesn't.
His attorney argues strongly. There's no solid evidence he was actually driving the car. No one saw him behind the wheel. No officer witnessed him operating the vehicle. The witness only saw him coming out of the grass after the accident. It's a bold argument and surprisingly effective. You can feel the momentum shift as the judge reconsiders the facts.
He was driving.
I'm not sure, Your Honor, there was anything additional.
Do you have anything else?
Your Honor, it does look like the witness stated that he stopped and exited his vehicle and observed the driver of the RAV4. That's what I have, but
So it doesn't match up with my client.
Kaiser Bono, Martinez stated once he stopped and exited the vehicle, he observed the driver of the RAV4, identified as Abraham Elias Salas, using driver's license, come out from the grass near the RAV4 and aggressively approach him, requesting to use his cell phone. Stated that he was trying to use his cell phone to call his mother to come pick him up, and that Salas said the RAV4 belonged to his mother. Martinez stated after a short time that Salas asked Martinez if he had papers for immigration.
Judge, even with these facts, it doesn't show driving. Even if he owned the car, we have no idea when. There's no facts to say that he was driving the car, that he admitted to driving the car. I don't see operation still.
So Salas stated that he was driving the RAV4 because he was going to a female's house and continued to speak. Salas then stated that he ended up in the grass because he was scared. Then stated that he was,
The judge digs deeper. Was there an eyewitness? A direct statement? Anything confirming he was driving? The prosecution struggles to bring clear evidence. All they have is circumstantial positioning and verbal admissions. This is the turning point. The courtroom quiets, waiting for the judge's decision.
he's fired to a police prior to his arrest. He admits that he was driving the vehicle at the time of the accident, and the vehicle was found at the scene of an accident. He was found nearby. Was observed coming out of the grass nearby. By the other driver.
Although it's an admission, Judge, there needs to be an admission plus. I don't see that being enough for the plus.
Mr. Salas, I'm going to find that there's no probable cause in your case. Every freaking day in our county, someone dies from an alcohol-related collision. Don't become a statistic because of a boneheaded move that you make where you kill someone. Do you understand? Now, I'm going to find no probable cause. It's very possible they go indict this case at a later time if they get more evidence, but don't kill anyone. Do you understand?
Yes, Your Honor.
See.
Thank you, Your Honor. Are there any conditions you're imposing on the evading case?
Judge Fleischer announces his ruling, no probable cause. But instead of letting the defendant walk out casually, the judge leans in with a stern warning. Every day, people die from alcohol-related crashes in the county. The judge tells him plainly, don't become a statistic. It's a rare moment of raw honesty and frustration from the bench.
Mexican driver that swerved in front of him and allegedly
He said a Mexican driver swerved in front of him. Is that what he said?
told him no Tango Propellus, or I don't have papers. Salas said the other driver was in a gray Toyota, telling him to go away. Stated that the RAV4 and the alleged Toyota came into contact, causing a collision. Salas stated that he was coming from his house in Friendswood, but denied having anything to drink. So
Yeah, I mean, I think if they,
he was operating the vehicle at the time of the accident.
and you have the other person say something, right?
They say that it was, they identified him as the driver.
They just never say they saw him driving or operating the vehicle.
So I believe that they They believe, based off the circumstance, that it was a driver. I don't know if the witness actually saw him driving, but we have to prove the driving facts is that
Judge Fleischer announces his ruling, no probable cause. But instead of letting the defendant walk out casually, the judge leans in with a stern warning. Every day, people die from alcohol-related crashes in the county. The judge tells him plainly, don't become a statistic. It's a rare moment of raw honesty and frustration from the bench.